FIR in this case was lodged by the Mayabandar PS on August 20, 2025 under the sections 20 subclause B, subclause 2, capital A, 22 subclause B, and 29 of NDPS Act. So, my lord, the last occasion by the trial court, the bail application was rejected on the 12th of November 2025. Your Lordship, there is a seizure of ganja of 21.23 grams, small quantity, 21.23 grams, my lord, of ganja, 21.23 grams, small quantity, my lord, and methamphetamine, 45.33 grams, my lord, which is intermediate quantity. And this recovery was not made from me, my lord. I am languishing in the custody only because of the co-accused statement which was made, and the persons from whom the recovery has been made are also outside on bail, my lord. They have been enlarged on bail. The custody period has been for more than 115 days, my lord.
45 grams meth was recovered from one Vignesh. Actually,
Not
not
from me,
from
my
me.
lord.
I cannot go beyond the record. Sridhar Babu is speaking. There is a big racket, 5 to 6 accused person. When one accused was arrested, he made a statement, I have procured from this person. And police raided, then some ganja was recovered, some methamphetamine was recovered. So thereafter, another accused confessed that I have purchased it from this account. तो खिलाना है ना कॉन्फ्रेंस हाईकोर्ट में करा देते हम लोग बड़ा देश आता था उसको मिलके दे देना पड़ता था तुमको वो व्हाट यू मीन कानून में was the first FIR. Yes, FIR. 20% yes. Second one was by the first one, who charges came. Sheet came. Yes. Intersection. In person, please. The other section is completed. So there were two cases. So there were no two cases. Not only sessions. Because it was never counted. Cases was no. So now saying, I think that you are yeah, I think I got confused. For my sons and yes, I see something because and that that's after publishing because we got such a situation.
Learned CJ Mayabandan. No, it is committed to the Honorable additional special court. Additional. I'll write and give my note. तो सर ये वाला इसमें स्पेशल My lord, the particular petitioner is in custody in currently in Patrapur jail with regards to another NDPS case, my lord. Just to inform.
Then I shall not keep the condition.
No, my lord may give. I'm just informing you, lord.
Take the permission.
Proper step. I understand.
Otherwise, that is when we get paid.
Rightly so. I understand.
Care of land council for the. You also in custody for the time.
I'll write on top. Ma'am,
We are in final sentence.
grateful, my lord.
For the respondent also.
Lord, this is an application for grant of bail. My lord, I will just show one order which my lord have passed during the last visit. I may not ask for clarity of reasoning, but the allegation is in such a way that
Not communicating order.
no, my lordship, I have just received the money. I have just received the allegation is I have received the money.
And from brother.
I have
From brother.
I have sent the money to some other persons. Then alleged offense was committed.
Yes, submitted.
My lord, what submitted 400 days is in the judicial custody. My lord, some because if he comes out,
And you have to say the grounds over here.
my lord, in bail, my lord, no, no grounds can be said. My lordship, it's at the mercy of my lords, I would say. I'm saying, my lordship, because it's like civil in injunction ad interim. I have to persuade the court prima facie. It is something like that. As I've said, my lordship, he's in the custody for last 400 days. My lord, do not get into the level of the offense. If my lord goes with the level of the offense, it's a murder, contract killing, payment came, men's were deployed. My lord, kindly do not get influenced with it.
States of Bengal.
My lord, kindly do not get influenced with it. It's an all allegations, remain allegation unless it is proven in accordance with law. But Lord, I will any condition, my lord, any condition, my lord, any condition,
Mostly area.
my lord, any condition, my lord, any condition which appeals to my lord, any condition, any condition.
Okay, 400 days. Charge sheet has been submitted.
Lordship,
What is the status of the?
Lordship, submission of charge sheet doesn't mean entitlement of bail. In a case of, kindly see the gravity of the offense first. Gravity of the young lady, 38 years of age, daylight murder. Near her house when she was returning from her duty, when reaching, followed by accused persons who are not a permanent resident of this island. They are the contact killer, came from Madurai district, Tamil Nadu. Tamil Nadu. Kindly appreciate this part because other two accused persons, which, not Bengaluru, from Tamil Nadu, being a contact killer, this petitioner taken a money. There is a strong evidence in the charge. Taken a money. Two other accused persons, Archana Kumari and her husband, granted anticipatory gold by this honorable court, Lordship, on different footing. At that stage of time, investigation was going on, initial stage of investigation, and this honorable court has found against them no evidence was found in that time. So anticipatory bail was granted. But kindly see the mode of attack, sharp weapon was used. Kindly see the postmortem report. The number of assaults or charge sheet for incoming. Charge sheet filed, trial commenced, two witnesses examined, Lordship.
It's turned hostile also, Lordship.
No, no, defector complainant on the basis of the statement of the defector complaint, who is the father of the deceased, he was a formal in nature, might be hostile, because on the basis of that, FIR have been lodged. But kindly see the entire charge sheet. I am giving the date, charge sheet. Comments, two witnesses examined, Lordship. First, Lordship, next date of I am coming. Lost up, Lordship. First things this court has to ensure, first thing, the attendance of the accused persons because they are not a permanent resident of the site. Second part, the case is based on strong circumstantial evidence. How they have engaged a car, how they have taken a two-wheeler, how they have proceeded to the place of occurrence,
Or a circumstance.
or Lordship knows circumstantial evidence is good evidence. In spite, if it is corroborated, there is a check. So kindly go to the entire charge sheet, Lordship. And they came from Madurai. There is ample evidence when they have landed through a flight, air ticket, boarding pass, everything has within the record. So my respectful, my appreciation that at least important witness may be given an opportunity to examine.
But to say that, gives back, evidence to be taken.
You know, I am.
You have to.
Second.
Let us before.
Then I will file, Lordship. Then I will file tomorrow, Lordship. Tomorrow, Lordship. Tomorrow.
Learned counsel for the, petitioner has submitted that.
Sold.
Custody for about 400 days. And although bad has gone. But there is no chance of it. I will come to the. Since how many people are there? How many?
Total charge sheet 26 number is 70, 70. 70.
17 cases. Are required to be.
Two witnesses already examined, Lordship.
Out of 70, are required to be. Yeah, some other active persons. Trying to access. Yeah. When it comes to the case, strongly opposite, it has not been. Actively, there are sufficient. Material. In the city. Which is in the channel. That it comes from the along with. Along with the. Sure. Bad have begun. And. Deeply. The last one here. There is. Some sort of. As. Since it's a accident of. You settle of the action. And it cannot be. If in cancellation. But I think they like. Sure. Is how from the record out of 70. There is no consent, but unprofitable of the other as the British Council for state wants to file its status. The state of the bad. And traffic.
Let's
You have to balance Article 21
Lordship.
and.
Lordship.
How many meters you want, actually want.
Lordship. This depends on each cases, Lordship. Yes, under section 302.
इसमें gaps कौन
हाँ इसमें है कौंसल स्टेटस ठीक है
Lord, I appear for the petitioner here in my lord. It's an application under section 483. Praying for bail. Yes, BNSS. Earlier it was 439 of CRPC, praying for bail.
How long you have?
But the case has already been charged.
required, Lordship. First date it is available.
Lord, I'll just say, my lord, the brief facts of the case is that father found the daughter in a compromising position with a young boy. Father went and caught hold of both of them. He slapped, the daughter escaped, the boy also escaped. After some time, we found that the boy was found hanging just behind the house in a tree. So abetting a minor to commit suicide, that case has been initiated and now it has been charge sheeted with her. Case has already been charge sheeted.
Lordship, even so, without paper, I cannot open my mouth, Lordship. Lordship, today is the first appearing in the news.
Let the case diary be called for.
Right, counsel for the petitioner has submitted that generally in custody for about
Lord, is 160 days, my lord.
160 days and that's it. Has already been submitted.
Because it is from Diglipur. So, day after tomorrow.
I'll have to school.
May it please your lordship, not application for bail, 41A notice issued to me. I am a resident of Gujarat.
CD not first. Tomorrow, day after tomorrow.
Tomorrow.
Tomorrow, no
cybercrime-
problem, here, see you, no?
Cybercrime case.
CID, tomorrow.
Then counsel for the.
Not wrong, correct.
It is very. This is not.
ये आ जाएगा, खाना खा लेगा, time
It's
लगेगा।
very.
खाना खाने के बाद अभी निकलेंगे 5 मिनट बाद हो गया, निकालो।
मेरा है मामला My lord, in this I am for the petitioner. My brother Rakesh Kumar is for the respondent. He's on leg before the other court.
Yes.
My lord.
It's fallen.
He's on leg before the court number, honorable court number 1. My lord.
So this is coming for the first time. So I've not served notice. Because
Counsel for the.
impugn not needs to be stayed, my lord.
Tomorrow, yeah.
Day after, day after. Yeah. Well, extremely obliged. Sabir advocate representing the petitioner is in indisposition. Let this be taken in the next circuit motion. Pursuant to the leave granted, I have interchanged the papers, Lordship. Now papers are in proper form. Babita madam was there.
Rakesh, yesterday I have corrected him.
No, let's wait. If not, tomorrow it can be taken. If not, tomorrow. Just pass on.
Yeah, I'm appealing for the, no, my lord. And I am for the responder, my lordship. Here it requires my lordship exchange of affidavit. So I will pray for filing AO, my lordship. Affidavit opposition, my lordship.
My lord. My lord, it's a very short matter because with regard to demarcation only. My land has to be demarcated, but within a certain time, my lord.
Then there is a resurvey is going on and we have instructed them to approach assistant commissioner because now the record is with them.
Within thereafter.
Okay, my lordship.
Lord, there is already a direction upon the private respondent to file opposition. Authority दे दिया? Authority दिया?
I'll take time because some more time is required. Just a moment.
नहीं नहीं इसमें हम दस नहीं खतीजा
I am for the official respondents, but no, I have already filed my opposition.
Well, right.
My lord, it can be disposed of, my lord. Here, this petitioner was charged under section 6 and 10 of the POSCO Act. After the evidence, my lord, 313 was collected, and on the basis of the evidence, he was convicted. I challenge this order before this division bench of this honorable court. And one of the 311 application was filed. No. Thereafter conviction was made. Conviction was set aside. One of the ground which I have taken that 313 was not as per the requirement of law. Court accepted my argument and set aside the. Now at the stage of 313, the court has reproduced all the evidence which were there. Now there are several incriminating materials, but I find that the cross-examination was not correctly made at that point of time. So, my lord, we filed a application before the trial court seeking under section 311 to cross-examine the witnesses on a particular, by putting particular question. That was rejected. Now, my lord, challenging the same, I have filed this. If my lord comes to my application before my lords, after 313 was over, at the stage of DW, we have taken out this application, my lord. Because in 313, all the depositions were as put to the witness. Because an earlier round, nothing was put in the 313. Now the copy paste, everything was done. So several incriminating materials were put whereby questions are there. There is no effective cross-examination. My lord, I am on Article 21 of the Constitution of India, my lord. He is on bail, my lord. He is on bail. But only, my lord, we have given the question. My lord, may kindly see para 6 of my application. My lord, I have given, my lord, 6 witnesses, my lord. Several witnesses were examined. My lord, may kindly come to page number 4 of my application, my lord. Paragraph number 6. I have put the questions, my lord. 2 question, 3 question, only not much, my lord, will find from para 6 to 7 this. So, my lord, no harm will be caused, my lord. Liberty of a person is. Yes. My lord, in the interest, my lord, they were having affairs, my lord. Only because she was not aged up 17 and odd something, my lord. That's why. Yes, trial court has rejected. My lord, rejection at page number 24. Ground, my lord.
What is the last? Yes, madam. Let us first Viti Shoga is appearing for the respondent. Viti Shoga, my lordship. He's in court number one.
Lordship, a short pass over we can also. My senior peers for the,
He's appearing for our case.
not today.
Okay. Problem.
Oblige okay.
For the applicant.
For the respondent.
It's against acute. That's what I did.
De facto complaint turned outside, my lord. Prevention of corruption. TW1, equal ball.
The complaint lot. Yeah, please feedback. And was responded to working in the DCO at Mayavad, the northern Udinata.
No,
No,
accused.
that's not. Officer of DC office. Was working as a senior investigator and clerk. Mayavad. The complainant was businessman running a restaurant, come bar. Complainant, owner of the restaurant, come bar. And for renewal of the license and the bar, he has to submit an application to the TCO for renewal of the bar. At that relevant point of time, respondent was posted there. He demanded rupees 10,000 from the complainant. And it was intimated to the anti-corruption unit by the defunct complainant also. Thereafter, team was constituted, accordingly raised to the place of occurrence. And pre-term proceeding was conducted for formality. Money was purchased. He was caught by the police of anti-corruption.
Defendant,
Even I will come for evidence. It is the big fact of the pre-term, then he was caught, recovery was made, then he was arrested. Then FIR lost, after investigation, charge sheet was filed. The prosecution examined.
so there is a anti-corruption, there was no complaint.
I am coming, complaint is there, complaint. Complaint. Then finally come to the page number 1 of paper, that is charge. Page number 1, first click. May I read lordship? First click, first charge. That is on 4th December 2014 at about 13:50 hours in your office. The DC office at Mayamundar, while discharging your duty as a senior investigator clerk, demanded rupees 10,000 as a bribe from the Vipul Bala. Vipul Bala is the complainant. For the purpose of renewal of bar license, and thereby you have committed an offense punishable under section 7 of UC Act within the cognizance of the court. That is the first charge. Then on the same date, time and place accepted the prime amount of rupees 10,000 from Bala for the purpose of renewal of bar license, thereby you have committed the offence punishable under 13(1)(d) of UC Act within cognizance of this clause. That is a charge. That's being a government servant taking a bribe. The prosecution or she was examined total 7 witnesses, including the defect of complainant and the investigation officer. 7 witnesses prosecution examined. Finally, state will come to the page number 2. That is the evidence, the position of the defect of complainant Vipul Bala. I may be read question. I am residing at Calcutta and running a restaurant in the name and style of Greek restaurant and bar. I have license to run the bar since last 4 to 5 years. The license of the bar is to be renewed every year. In the month of December 2014, my license for running the bar was expired. That says my license was expired on 27th May 2014. I applied for a renewal of the same before the Deputy Commissioner Office, Mayamundar, maybe in the month of January or June 2014. After applying for the same on 2nd December 2014, Shomon Mishra, the clerk of DC office demanded rupees 10,000 from me for renewal of the bar license. So, Toshi, money was demanded by the respondent, that is there. Money was demanded from whom? From the defector complaint. It is a strong evidence of the defector complaint. So, regarding demand, it is stated by the defector complaint. Again, I am repeating, Lordship, for demanding money, it is between the defector complainant and the accused person. Accused never will come and say that before the witnesses, you give the 10,000 rupees.
Person comes and say that somebody demanded, right? That is not the law. From my friend, some other witnesses and etc. That I have understood.
Lordship,
So if I say that.
Lordship, gratification, bribe money demanded by a government servant cannot be before any independent witnesses. Cannot be. One government servant.
There are procedures.
Lordship, then why defector complaint? Lordship.
Understood. That if it is that evidence is so that the person complaint should go to agency, and when he demanded money to pay money and substance of such event.
Lordship, one government servant who is taking a bribe, illegal gratification, Lordship, we have to see the first, that is the between the defector complaint and the accused. That suppose, Lordship, if recovery is made, same note, suppose 10,000 demanded by that from the defector complaint. Then defector complaint arranged the anti-corruption team was constituted, reaching to the place of occurrence. On the basis of that demand, first demand, that you paid 10,000 rupees, the defector complainant had paid 10,000. Then immediate police rushed to the area, recovered the money. It was because with the preacher proceeding. Because preacher proceeding for telling the note, handing over the note currency to the defector complainant that you give the money because the money was demanded. If that was tallied, that demanding of that 10,000 rupees and recovery from the accused person, if tallied that same notes, currency note, that demand and acceptance proves Lordship. So kindly come to the evidence, Lordship. Next one. As per the formal renewal of the bar license, on hearing that I went to anti-corruption and one officer of anti-corruption asked me to return complaint. Accordingly, maybe on 2nd December 2014, though I cannot remember the exact date, I lost a complaint scribed by my one officer of the anti-corruption as I do not know write English. Thereafter, I put my signature on the complaint. Therefore, is the prayer of the prosecution. Then, further examination. Next page, page number 3, Lordship. This is the Xerox copy of my complaint which bears my signature marked X for identification. The Xerox copy of complaint was contained my mobile phone number. Lordship, regarding original, I will explain where the original or not exhibited or not true, I will come to that. Someone which was demanded 10,000 from me, present today in the court to identify the accused conduct. On 27 May 2014, I submitted an application for renewal of my bar license and degree qualification. Someone which on the one other reason delayed for the same, I demanded 10,000 for renewal of a license. Then some writing is found in the palm of the complaint witness and for which he is not examined today and the such the case is deferred today to the next. And further, page number 4. Page number 4. I cannot remember anything which happened on 4th December 2014. At this stage, landed duty in charge declared the witness hostile on the basis of the application for declaring the witness hostile as the same be allowed and is for the because the defective complaint regarding demand of money only stated that is my respectful humble submission that demanding money has been deposed by the defective complaint. Then next one, I am a farmer by occupation. On 4 December 2014, I was holding a bar license for running a bar. I cannot remember if I made any application to the Deposition Commission, Northern Middle Andaman, Myanmar for renewal of the same bar license. I also cannot remember if I put my signature on the document unless it is shown to me. Pre-trap memorandum is shown to the witness. Lordship, pre-trap memorandum means before proceeding to the place of occurrence, some demonstration has been taken regarding sparing of the powder, regarding handing over the notes, that was done. These are my two signatures on the pre-trap memorandum marked as exhibit P1 by 1 collectively. Handing over memo is shown to the witness. This is my signature on the handing over memo marked as exhibit P2 by 1. Recovery memo is shown to the witness. These are my three signature marked exhibit collectively. Then I read up to class 7. I know it was 4. Sorry. I read up to class 4. So why this witness was hostile, Lordship? I cannot go beyond the record. This witness was hostile who has made a complaint, report the complaint. I am reading, scrutinizing, rising this evidence of PW1 as because I intend to prove that demand was made to the defective complaint by the accused person. If the demand is proved, Lordship, then question recovery by through a shadow witnesses, I will come to the evidence of that part. Whether recovery was correctly proved by the prosecution before the trial court or not, that has to be seen by the court, Lordship. So kindly come to the page number 6 of the paper book. That is one PW2 RF. I am now posted a higher grade clerk in a GA section secretariat. On 3rd December 2014, I was posted in the same place as a grade clerk. On 2nd December 2014, I received an order to report an anti-corruption unit on 3rd December 2014, and accordingly, I attended anti-corruption unit on the date at about 8 AM along with one Vinith Nair, LGC, who was posted with me in the same section. We were asked to report along with our personal belongings and accordingly reported there at about 1:30 PM after lunch. Therefore, you were asked to board in the vehicle along with other police personnel and we proceeded to Myanmar. We arrived at Myanmar during night time. On the next day, at about 10 AM, we were informed about late trap. Accordingly, demonstration was held a quarter near Mini Syria, where we were staying. During demonstration, we were asked to dip our hand in plain water and color of the water was changed. Was not changed. Sorry, was not changed. Thereafter, Inspector Daniel took out some currency notes and smeared some powder on the same and handed over to same to Vinith and asked him to hold the same. Thereafter, Vinith dipped his hand into a solution and color of the water was come out. The complainant was also present there. Inspector Daniel handed over said currency notes to the complainant to hand over the same to the accused on demand, and he was asked to give the signal after payment. A document was prepared and signature on the same, which document was in the pre-trap proceeding. Dr. Complainant admitted his signature was exhibited. Pre-trap memorandum is shown to the witnesses. These are two signatures on pre-trap memorandum marked as exhibit P1 by 2 collectively. At about 1 PM, we proceeded to DC office at Myanmar, and after arriving there, we were asked to take our respective position. And I took my position near the stair. Beneath that, another police person went to the first floor. The complainant also went to the first floor of the building. Thereafter, the complainant came out and rubbed his hair. That is signal. And after getting signal, all of us rushed to the first floor and entered into the room. After entering, I found two police personnel got hold of the Saman Mishra having currency notes in his right hand. So here recovery, Lordship. Here kindly see the recovery. Now question whether that note carry, why the note reach to the hand of the accused person. That is the main aspect of it. Then Inspector Daniel took the money from his hand. Thereafter, Inspector Daniel asked the accused to dip his hand in two glass tumblers and color of water turned into pink in both the glasses. It means powder was mixed with the currency note. Inspector Daniel also tailed the number of the GC note with the numbers already noted by him on those who are found correct. So it was tallied from the detail.
Yes, but this was not mentioned in the. And you see those was also. Okay, we will be there. That has not been.
Not mentioned, not mentioned. I will come with the other witness as I stated. Thereafter, the hand wash of both hands were collected in the two separate photos and those were sealed and labeled in my pages. I also put my signature on the label. Thereafter, document was prepared and I put my signature on the same. Recovery memo is shown to the witness. These are my three signatures on recovery memo marked as exhibit collective. Inspector Daniel handed over a draft sheet to me under the cover of handing over memo and I put my signature on the same. This is my signature on handing over memo marked as exhibit P4/1. Thereafter, we along with the accused and see the article proceed to court at about 3 p.m. and arrived here at about 11 p.m. On the following day, I handed over the draft sheet to a police personnel and anti-corruption unit. Accused someone with a suspended today, identified accused conduct. This is my signature on the label of bottle containing right hand wash of the accused. Signature is marked as fact object 1/1. This is the said bottle containing the right hand wash of the accused marked material absent 1. This is my signature on the label of bottle containing the left hand wash of the accused. Signature is marked as the match object 2/1. This is the said bottle containing left hand wash of the accused marked by exhibit 2. This is my signature on the envelope containing currency notes. Signature is marked as match object 3/1. These are the currency notes marked as material exhibit 3. Currency notes was these. It was exhibited, currency note, then cross examination. It is the first shadow witness. Case number 11 is a Vidit Nair. I will not take the much time of this preposition because Vidit Nair and the PW2 are the witnesses who work in the secretariat under administration. They were called that we are going to ready a person. Same thing has been stated by Vidit Nair, that is page number 11. PW3, that data proceed is beginning, proceed to the spot, data recovery, everything. That is PW3. PW4 also police personnel lordship. PW Basudev Parmar. So kindly come to the deposition, page number 16, last paragraph. Page number 16, last paragraph. First portion I will not read, lordship, because it is an introduction that where he was posted, when he was married, lordship. Thereafter, the complainant handed over 5,000 having renovation of 5 notes of rupees 1,000 each. Thereafter, exam procedure was conducted and during demonstration, 2 glasses of water were taken and one of the independent witness was asked to put his hand in one of the glass tumbler and while doing such, color of the water did not change. It is before Peter. Next page number 7. Thereafter, the said person touched the phenolphthalein powder and he was again asked to dip the same hand into the glass of water and on doing such the color of the water turned into color. That is the demonstration. Read that, lords. Thereafter, currency notes of 5,000 are also treated with the phenolphthalein powder and covered in an envelope and thereafter it was handed over to the complainant. This note. The TLO. Brief the reading team about the procedure of raid and thereafter we leave the spot at DC office, Mayabadar, and reach there at about 13:50 hours. The complainant along with the independent witness and the PLO entered into the DC office and we were waiting at the ground floor awaiting signal. After getting signal from the DLO, we rushed to the first floor and on reaching the chamber of the accused, we found the DLO holding the right hand of the accused. Accused Samar বিশ্বাস is trap laying officer who has
Who lead the team of trap?
trap laying officer. Which is PW number 4. PW 4. Masude Barle, CL, trap laying officer, under whose supervision entire process was conducted. The DLO asked me to photograph the process.
No, sorry, I am sorry. Trap laying officer was Inspector P. Daniel, who died and he could not be examined. He was the trap laying member. Not the
What is the trap laying?
Yes.
What is the trap? What is the trap laying? The DLO asked me to photograph the process. In the process, the DLO recovered the 10 currency notes of rupees 1,000 from the accused. Then 2 glass number with the water brought and hand of the accused was deep into the water and the color of the water changed into pink color. The said solution was taken in a bottle and sealed and signature of the witness were taken on the and seized. The recovered tainted money was also sealed and seized in presence of witness. There the accused was arrested, brought to the anti-corruption unit, Blair. Mat of the Q2 and mat of the P3 are shown to the witness and witness identified the same. This is my signature of the steel trap memorandum marked as exhibit P1 by 4. This is my signature of the recovery memo marked as exhibit P4. So regarding that recovery of money lordship, changing of color, because money was with the hand of the actor, which was seized by the DLO, Daniel was not example. DLO has seized that money when after feedback proceeding, when the pardon was smeared with the notes currency, now the hand of the accused person dipped into a water that it was color has been changed. So kindly see the sequences, the circumstances, and the chain of the prosecution cases, Lord. Then PW5 is also a rating and he was with the team member. I will not read out because he has supported the PW2 rating team members also. That how the PW proceeding was conducted, the recovery was made. Then PW6 was registered the FIR of that is PW6. PW6 Swapal Kumar Sarkar Lordship. He is the investigation. PW.
No, that is the FIR writer.
That is FIR writer.
7 is the IR.
Only as the FIR writer also. Message was received, then FIR has been lost on the direction of the investigation also. PW7 is the Swapal Kumar Sarkar Lordship. He has created the case lordship in trapped proceeding lordship. The arrest of the accused, thereafter nothing remains for further investigation. Trapped, everything has been done. That document has to be recovered by the investigation. That has been done. Supplementary experts' opinion regarding that color solution.
Oh, he
That
was
was
not
done.
examined. The expert was
That exhibited or not, I will come.
exhibited, not examined.
So investigation officer or that page number 26 is the examination statement under section 330. TRP also. So I will come to the page number. Start from page number 72. Page number 72, that is result of the examination is page number 72. Result of examination. Chemical and chemical examination. Examine 1 and 2 are found to contain that is phenolphthalein and sodium carbonate, that is our exhibit 3 was also found content, that is currency note lordship and that bottle 3. So expert opinion saying yes, that contains currency notes and the bottles colors, bottles that contain some of the. So regarding demand acceptance lordship, demand always I agree submitting lordship, demand by the accused from the accused complainant cannot be before the witnesses concerned, cannot be in open places. If a de facto complaint specifically stated in his deposition, yes, he has demanded 10,000, out of which 10,000, 5,000 has to pay, and it was recovered.
I now tell me why he has said that I have paid the sector.
Nothing in there, nothing in there. 10,000 asked, then why 5,000 recovery is seized? I don't know, Lord.
But he cannot remember what happened.
What happened thereafter? I cannot.
This free also.
Lordship, that I read out. What he stated, I stated, fairly I stated, he declared hostile, Lordship. Fairly I stated. Clearly, I have stated that he was declared hostile. Only that part he demanded and.
Whether he has paid on that day or not,
That is not in the deposition. I am just.
No, he just got the license.
Bar
He
license.
got the bad license.
That is not on record.
Huh?
That's not there on record. Even I was the person who was dealing with this, is not on record.
I have completed.
May I just take my lord to, I'll just take the bullet points. My lord, may kindly come to page number 33, my lord.
Faculty conviction should be done.
Lordship.
Why he has not convicted? What is the ground?
Lordship, that different.
Prosecution fails to prove the case beyond all reasonable doubts.
Just.
Not to inaccuracy.
My lord.
Considering all, I think the prosecution, that is anti-corruption unit, has failed to bring home the charges leveled against the accused and the accused deserve acquittal from the case.
May I draw kind attention of my lord towards page number 33 of the paper. This is the first information report, my lord, which was received by the police station anti-corruption on 4/12/2014. Got it, my lord? Now, my lord, may kindly come to point number 3, occurrence of offense. Information received at PS. Date is 4/12/2014. Timing is 13:10 hours. That is 1 p.m. 10 past 10. It's 13:10. Now, my lord, may kindly come to page number 50, my lord. This is the pre-trap proceeding. 50. Pre-trap proceeding. Now, when the pre-trap was conducted on 4/12/2014, this is technically very strong reason why I say, my lord, the entire case of prosecution is based on hypothetical story. The pre-trap proceeding arrest to have been conducted on 4/12/2014 at 12:10 hours. 1 hour before lodging of the FIR. When there was no FIR on existence, how then the pre-trap proceeding was initiated by the DLO? Now thereafter, my lord, may I just take my lord to page number 53. Page number 53, my lord. As per this is the recovery memo after the raid was conducted, my lord. Kindly take a note of it. This is also important as per the timing is related. As per the recovery memo, today on 4/12/2014 at around 13:45 hours, the trap team consisting of self as trap laying officer and the independent witness so and so, they reached the DC office, place where the
trap was laid down. But my lord, on the same time, if my lord may kindly come to PW4 and PW5, the recovery memo was prepared at 13:45 hours, whereas PW reading team member, PW5, the reading team member, they say that page number 17 and page number 20, they reached at 13:50 hours. So how the recovery memo was prepared at 13:45? If the entire team, as per the prosecution witnesses, reached at the DC office at 13:50, 17 and page number 20, my lord. Page number 17, third para, my lord. Starts from the TLO, briefed the raiding team about the procedure of raid, and thereafter we left our spot at DC office, Maya Bandar, and reached there at about 13:50 hours. Got it, my lord? Similar is at page number 80, my lord. The another team member, raiding team member, page number 2020, my lord. Same third part, my lord, stereotype chief is there, and the same reply comes out from the mouth of the witness. So, as per the trap laying officer, the memo was prepared at 13:45 hours. But the team member says that they reached at the spot at 13:50 along with the team. 53, my lord.
And around 5 minutes there.
5 minutes, yeah. And my lord, may kindly appreciate, 5 minutes is not that valuable, my lord. What I'm trying to impress this honorable court is, my lord, assuming for a moment if they reach by 13:45 also, it will take at least 15-20 minutes to just conduct the raid into recover the things, my lord. But recovery memo says 5 minutes prior to their reaching to the spot. Now, my lord, I'll take straight away my W1, wherein my brother harps with the things. This particular witness was deferred on one occasion at page number 3 because date of incident, everything was written in his palm. So he keeps on looking at the palm doc. So I pointed out this to the trial court, and then he was deferred on that particular day. Thereafter, he turned hostile, and Your Honor, may kindly, I beg pardon, my lord. My lord, may kindly see page number 4, the cross-examination. I do not know to read or write English or Hindi scripts. I cannot say the contents of document in which I signed. I have not been shown the original complaint submitted by myself. It's a fact that I falsely stated in my deposition dated 26/10/17 that accused Samar Biswas demanded 10,000 rupees from me on 2/12/2014. Entire thing goes. And the original complaint, my lord, which was handed to the trap laying officer, is not the part of the entire charge sheet. It was not exhibited also. Original written complaint of the de facto complainant is missing from the entire document in the charge sheet. It has not been exhibited. Pursuant to that written complaint, the FIR was chalked out. Thereafter, my lord, I'll take the bullet point of the cross-examination. Kindly come to page number 9, my lord, of PW2. Fine, my lord. I did not see the complainant handing over the currency note to the accused, nor the accused to the complainant. What I wanted to I went to the said room after entry of other trap team members. I cannot say if the police made the accused hold the said currency note. I cannot say if the phenolphthalein powder was smeared on the hand of the accused. I do not have any idea where the recovery memo was prepared. I put my signature handing over seal at DC office Mayabandar. Now thereafter, my lord, skipping 3 lines, the color of the solution is similar to the color of the water. Both the hand of solution turns white like water when it was produced before the witness on dock, before the trial court. It is a fact no complaint was shown to me during the trial process carried by Inspector Daniel. Now thereafter, my lord, PW3, I'll just take my lord. to page number 14, my lord. 1-4. On the top, my lord, I did not see the complainant handing over the currency note to the accused, nor hear the accused demanding money from the complainant. So admittedly, this witness has also not supported the case of prosecution regarding demand and acceptance of the money.
Senate Council for the case as submitted, said the accused or and that in office as another you voted in you get the foundation the important of restricted and bar another.
At Diglipur, my lord. He was from Diglipur. He applied at Mayabandar for the
Of renewal of the bar. The private application. Or performance of it. He was and date all already by the case. I perfectly take against the prosecution. It's a case. Although the point was that each other. And they have also supported this of mutual needs. So, the other witnesses such as you don't know, you don't do fighting and you don't have Yes, they are. Come on. That is that the accused from all charges. Only that the solution was not is against the accused. Beyond all of stuff is given. So. Regarding counsel for the RP.
Turkish powder.
Yes. This Palpudi has gone. The attention of the school. The conflicts of Raida and that he has out from the point that one hour before, 1 hour before, for the conflict. he has also drawn the attention of various agencies. The evidence also. As the evidence of similar witnesses. Appears from the prediction of one. Yes. And and it also stated in this equation dated 26/6/2017 that you be shall United States from the and the shadow intervention as categorical stated as that that they did not see the component handing over the currency use. Or they are the not supported from future. Sure, it is factor way after what we examine in the guy. Oh. Oh. Giving back, giving back, try giving back. Because other shows that we monitor complaint complaint. But philosophy of complaint was produced, and ultimately then was not academic. So I find service evidence of prosecution and of this stage of imagination that the prosecution has been begins the pure people get compared. Here in number. More or less.
Oh, shit, sometimes I cannot.
In this type of case, demand of right and acceptance of such self-gratification has to be proved beyond reasonable doubt, either by way of direct evidence or by circumstantial evidence. In this case, the prosecution has himself that is against the
Grateful man. Right.
This is the one yesterday we were started. That was the kind of discussion.
Page number also. Page number start from 150.
152. Well, because one by the complainant, one by the
Well, item number 51, my lord. The item number 51, my lord. There is a interim order till 6th, my lord. The other side has filed the affidavit of opposition. I have to file my reply. I require 10 days time, my lord. It has to be in the next circuit. Other side is there. They have given copy yesterday. Other side is there, my lord. Till 6th. Till 6th is there, my lord. But the reply is filing only on in the next, 10 days time is required. Seventeenth, my lord. My lord. Affidavit in reply. I'll use that.
My lord, item number 25, my lord, moderate, my lord, if you have some. 25 cannot taken today, my lord, tomorrow that. Suppose, Babita, parted matter, my lord. My lord has had the. I'm grateful. I'm grateful. Yes, sir.
Lordship. While you come to the state, you took the order. Lordship, page number 153. 153. Para second. On perusal of enter record. No, Lordship. Page number 156. Order dated 29.
that's what. Yeah, take this.
No, that's the. 29/7/2024. Page number 156. On perusal of the entire record, I find that the marriage took place between Bhavna Sharma and Neeraj Sharma. Bhavna Sharma expired, Lordship, and Neeraj Sharma is the main husband, Lordship. In the year 2018, and they came and started staying in Andaman and Nicobar Island in rented accommodation in May 2018. If that be so, then residing of other accused person except accused Neeraj Sharma with the deceased at Port Blair does not arise. I also find from the record that on the day of incident, that is on 8 July 2021, something happened in between Bhavna Sharma and her husband. And due to that reason, her husband did not take breakfast, and when at noon time he came to his house, he also did not take his lunch. It is not the question that he did not take breakfast, as he had no time to take the same to attend his office. But it has been clearly stated in charge sheet that he went to his office and took breakfast there. It means something happened in between wife and husband, and due to that reason, he did not take breakfast. Further, after coming from office, he also did not take lunch, and thereafter in the evening, when he came, found that the door was locked from inside of his house. Then he called his neighbors and opened the door and found that his wife was in hanging condition, and his daughter was also lying in dead condition, who were declared dead by the hospital where they were taken. If that be so, then it can be said just before the incident, if one altercation took place in between husband and wife, which resulted to the said suicide incident by wife of Neeraj Sharma. The said incident took place within 7 years of their marriage, and death was not natural death. If that be so, then prima facie is attracted to provision under section 304B of Indian Penal Code, as because it will be proved during the trial that was the reason exactly for which Bhavna Sharma committed suicide. See, there is no allegation of harassment from the side of accused Neeraj Sharma for demand of diary. That is why prima facie it also attacked the ingredients of section 498 of Indian Penal Code. Hence, there is a sufficient material against accused Neeraj Sharma to frame the charge under section 498A and 304B of Indian Penal Code. Your Honor. It is in respect of Neeraj Sharma. He was not discharged. I am not challenging that part. Next page, 158.
না ওটা এখানে একটা জিনিস আছে there's one thing man in the state one Neeraj is not a party, he was never discharged. There only I am a party, but in the one filed by Mr. Tulsi Lal, there four of us are there plus husband who's not discharged, he is also a party. Mr. Elango is appearing for him. Oh, I'm just pointing out that Neeraj is there in the other one.
I will take only. The next page, 158. I do not find sufficient materials against the rest of the accused person, namely Binay Kumar, alias Binay Sharma, Aman Sharma, Ravin Kumari, and Shashi Gala to frame a charge under section 498A, 304B, and 34 of Indian Penal Code, as because prosecution prima facie failed to show their presence either at the time of incident or before that at court there, as because immediately. Lordship, I can say straight a wrong observation, Lordship. Because, Lordship, for 304B, against husband of the deceased, his presence was proved by way of filing a charge sheet by the police. But how this observation has made by the London trial court regarding, I am frankly can say that 304B, of course, not in respect of other three discharged accused persons, Lordship. Kindly say the 498A and 34 IPC, that is the common intention. 498A, I will come to the definition of 498A. Lordship, so these are saying that you are saying that discharged accused should be 498 and 34 IPC, Lordship. Not 304. No, not 4B, Lordship. We are saying that they must be charged under 498 and 304. Why I am coming, Lordship? Because the London trial court has stated that the presence of this accused person is not proved. There is no evidence in the charge sheet. On the date of incident, when it was found hanged, before that also, they were not found. On that basis, entire sections, they all, the accused person have been discharged from all the ingredients.
The explanation of the 98A, the explanation A of that the immunity must be such an extent that it drives the,
I will come to the evidence.
drives the.
I will come to the evidence. Lordship, 498A.
This is a 498A and.
Lordship.
4B can be there.
No, Lordship, 304.
Basis of the audit.
I am not harping on section 304B in respect of discharge accused person, Lordship. I am on 498A, Lordship. 498A, Lordship, deceased expired. Who will prove it? Who will prove it? 498, because this is wife expired. We have to see the circumstances after the marriage, just because it was happened within a 7 years.
No, there is statement of witnesses.
Lordship,
With the.
no, independent witness cannot be Lordship. The father of the Lordship. No, not at all. No independent witnesses. Father of the deceased, mother of the deceased, brother of the deceased, and the sister of the deceased. Lordship, since beginning, after marriage, what was happened regarding demand of dowry, regarding harassment, regarding mental torture, that has been came in the record, Lordship,
By all the.
by all the accused persons. Tas, Satur, Sab. So, my respectful humble submission that impugned order in respect of 300B, 4B, 498A 34, that presence of the accused persons other discharge were not found, that was held by the trial court. Totally wrong. Totally wrong. 498A, kindly see the since beginning.
Then why you are using 340?
Last show, kindly come to the section 304B also.
Now, before that, 498,
Last show, I am coming. I am coming.
you cannot believe. If you argue.
I am coming, Lord. Just one. Lordship, 498A, Lordship. Husband or relative of husband of a woman subjecting to her to cruel. Whoever, being the husband or the relative of the husband of a woman, subject such woman to cruelty shall be punished with imprisonment for term which may exceed to 3 years and also be liable to fine. Explanation. For the purpose of this cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide. Or
Already committed suicide. You are saying that they should be charged under section 498 and 34, not under section 304.
I am coming 304B, I am coming the definition law. Kindly see the explanation. Then commit suicide or to cause grave injury or to danger to limb or health, whether mental or physical, of a woman. So here Lordship has to see from the charge sheet, from the face of the charge sheet, after the marriage, this woman victim deceased to hang herself with a child. That is, what type of mental torture have been created by the relatives of the husband? That has to be seen, whether that is evidence in the record or not.
Now,
If
how they can, they are deciding in Punjab.
Lordship,
What
because after marriage, what was actually happened? Demand of dowry by the other person, discharge accused person. Father-in-law, mother-in-law demanded how many times from the father of the deceased? Many occasions. When they are residing in a matrimonial home, then they have been transferred from here, Port Blair. Then she committed suicide, Lordship. At that relevant point of time, these discharge accused persons were not present, of course. But kindly see, after marriage, since beginning, mental torture itself a cruelty, ingredients of the cruelty. So since beginning, after the marriage, all the persons, including the husband of the deceased, compelled the victim girl to commit suicide. So see, because in one day, suppose I said something due to the angry manner that no, something disputes arising between husband and wife. For one day, one woman will not make suicide laws. Because just after a marriage, since long it was going on, then she committed suicide. So that since long tenure, that evidence has to be seen by. So because 302
case was registered against women. That was awaited nothing, but that was unknown to everybody, Lordship. That was unknown to everybody because the child was with the mother, the deceased. Would have been happened due to the mental torture of the all family members. She decided
To kill her baby.
baby and own self and we cannot say, we cannot say. So the extremeness, the limit of the torture, and moreover, Lordship, discharge of the accused person from the case. We have to see the only prima facie evidence to proceed with the trial, to commencement of the only prima facie evidence. Disputed questions of fact, disputed questions of law cannot be taken at this stage. So grounds have been taken by the trial court. Lordship, I am coming. The statement of Jagjit Kumar, the father of the deceased. Lengthy statement. I can hand over the case diary, Lordship. If Lordship permits, Lordship, I shall also. Charge sheet. Charge sheet submitted. Yes, copies. So entire statement sees beginning how the marriage was conducted, whether it was an arranged marriage, after marriage, where the husband was used to reside. I flag it. I flag it.
So
There are sufficient materials only to commencement of the trial.
one or two, like,
Lordship, I am coming. One or two. I am coming to that. Just a minute. Lordship, first, may I read Lordship the statement of Jagjit Kumar? मैं अपने परिवार के साथ पते पर रहता हूँ तो आर्मी में रिटायर्ड हूँ 5 फरवरी 2018 को मैंने अपनी बेटी भावना को शादी जस्ट नेक्स्ट वन जिसमें मैंने नीरज के परिवारों को कपड़े आदि भी दिए थे 5 लाख रुपए जो मैंने दहेज में दिए थे वह मैंने कमेटी लॉटरी में बांधे हुए ऐसा लेकर दी थी शादी के कुछ दिन बाद दिनांक 28 फरवरी 2018 को जब हम भावना के ससुराल गए तो भावना के सास और उसके पति नीरज ने कहा कि अपनी बेटी को वापस ले जाओ हमें नहीं रखना है उस समय पहली बार नीरज ने भावना पर हाथ भी उठाया था और हमसे 5 लाख की मांग कर रहा था so that demand Lordship, I flag. Lordship, so my respectful submission, this should be failed the trial because only prima facie. Then I will come to 304B also definition, Lordship. At least 498 and 34, at least. Lordship. Lordship.
Yes, complicated. Right, no. For some problem. I have released all matters for you. I will. So you complete
50 state application, 52. No, 54.
No, my lord, tomorrow again, other matters are fixed, my lord. Same matter we are going to keep arguing. This matter has been pending for now quite some time.
I have concluded, Lordship.
My lord, I will beseech your lordship. I will just show the documents, actually the situation from the CRAN. Kindly take up the CRAN which is there. I don't know if this is 1 or 2, but this is the CRAN that was filed for stay. I will show the papers from there. My lord, kindly comes to page 11 first. What is the actual fact? Let us see and understand. Page 11, kindly see FIR number 68. FIR number 68 under section 498A 304B. Date of FIR 31/7/2021 at 1:10 p.m. 31/7/2021 at 1:10, 13:10. Section 498A 304B. Occurrence from 5/2/2018. That is the date of marriage. They are saying date to 8/7/2021. Yes. Now, this is the first FIR which is lodged by SI Samiran Mirdha, number 6. Kindly see the same page, serial number 6. Complainant SI Samiran Mirdha. So police has lodged the FIR. No FIR was ever lodged by any complainant. Now the picture is this. This is the first step. Now kindly comes to page 15. So page 11 is the first FIR. Page 15. Now this is FIR number 57 of 2021. Dated 8/7/21. And this FIR is under section 302 straight 21. So the day of the hanging, the day that the incident happened, this was the first FIR. 8/7/2021. It's this is state's copy. It's not disputed. I am showing from state's petition. So 8/7/21, kindly see the complainant is the neighbor, Vikrant Malik. Accused unknown. My lord has got it at the bottom. Accused unknown. Column number 7. So what actually happened? On 8th of July, the husband went to his office at the Navy base. He had a fight with the wife. He didn't eat breakfast. He didn't eat lunch. When he came back also, he didn't eat. He went out. Over this, there was a fight. Now later when he comes back, the door is locked from inside. So the door is broken and they find wife dead, baby dead. So the first FIR is by the neighbor and it's straight 302. This was the case which was investigated first. Now in this case, they tried to make out a case against the husband of 302. My lord.
What the information was received by from a neighbor. So.
No, information was received in the night, 22:15.
He was came and opened the.
Broke the door.
Why he has not got this.
Immediately at that point of time, the neighbors and everyone were there. When Neeraj came, I'm telling you, Lordship, kindly see the first information that is coming. No, postmortem I'm coming to. I'm coming to that. Now, he has come home at 6:35. 6:35 to 19:30, 1.5 hours. Neighbors were there, they broke the thing. Thereafter, they did not stand there. They rushed the wife and child to Navy hospital. Then at Navy hospital, they were checked. They were declared brought dead. Then information went to the police station. That is why that 3 hours delay. Because in that 3 hours, Navy personnel came, they rushed, he's a Navy officer. They rushed him to INS Dharmantri. They tried to revive, they tried everything, could not. Then at 10:30, police is informed. Now at that point of time, the suspicion is unknown accused. Not against Neeraj or anyone else. Now kindly comes to the first inquest, page 53. Here my lord will get page 53. Neeraj is not discharged. No, he didn't pray for discharge. Neeraj is contesting the trend. Because I'm showing why. I'm showing why. No, I'm not appearing for Neeraj. I'm appearing for the other four. Father, mother, brother, sister. Neeraj is Mr. Anand.
But I am
He's hiding
it
here.
as a party, not a party.
But Neeraj is not relevant in this. Now kindly see page 53. 53 is the inquest which is done. Now I just said the body was taken to Navy Hospital. Kindly see third line. I will make the entire case clear so that my lord can then decide. 53, kindly see third line. The body was at INHS, Indian Navy Hospital ship Dhanvantri on 8/7. Third line from the top. Report of investigation under section 174 on the body of a person found dead at INHS Dhanvantri on 8/7/21. So this is the inquest of the wife. Now, column number 3. Name of deceased, sex and age, Bhavna Sharma, female 31. Thereafter, inquest is done. And my lord will see page 55, first of all, first line. First line, oblique ligature mark. Oblique mane hanging. Because from the back it is there, so not manual strangulation. Then next page, 56. As per the opinion of the punches, the cause and manner of death is asphyxia due to suicidal hanging. Now kindly see postmortem report, page 57. Next page. This is postmortem of the wife, Bhavna. Now, postmortem, everything is there. Second heading, information furnished by IO. The deceased was found hanging in her house on Atho at 6:30 p.m. She might have committed suicide due to some family dispute. The house was locked from inside. The door was broken over by neighbors and friends. The daughter of the deceased, Kumari Rudrika, aged 1.5 years, female baby, was also found dead lying on the bed. Thereafter, second last line, or external injuries, antemortem ligature mark is oblique. Then measurement is there. The skin over the ligature mark is dark brown, hard and parchmentized. On dissection of the neck, tissues beneath the ligature mark are pale and adjacent. Soft tissue is ecchymosed. Hyoid, bone and thyroid cartilage are intact. One is suicide. It is not a case of homicide because hyoid bone is not broken. Now, kindly see, very important, page 59. Page 59 has two things which are very vital. First thing is, in the middle, provisional opinion as to cause of death. Death was due to asphyxia consequent to hanging. And now I want your lordship to read the last 3 lines. Note, it's very vital. On 12th July 2021, with the request of Mr. Neeraj Sharma, the husband, and father of the deceased Bhavna Sharma and Rudrika, the bodies has been embalmed using necessary chemicals to facilitate transportation to mainland India. The husband asked for the bodies to be embalmed, so the bodies could be taken back to the mainland for necessary cremation or disposal or whatever. This is very important. I'll say why. Now, kindly see page 23. This is the first charge sheet. This is in the wife's death. So I have shown 8th July, FIR was 302. Postmortem, husband has taken the bodies and gone back. 31st July, the complainant is coming and saying 498A, 304B. In between, I have taken the body, the husband has taken the body and gone.
After the father's house.
Punjab only. Now, kindly see,
Both of them belong.
and I'll show your lordship something very interesting. Anyway, page 23. This is the first charge sheet in the 304B 498A case.
The first charge sheet.
In the 498A case, 304B 498A case, in that FIR, this is the first charge sheet. Page 23. In this, they are naming Neeraj as the accused. Now kindly sees page 34. In this particular charge sheet, the attempt is to name 5.
54.
Mind. Now page 34, kindly see the investigation, what has been found. पढ़ो तो
इसमें यहाँ से पढ़ो। दौरान तफ्तीश मृतिका भावना शर्मा के पिता श्री जगजीत कुमार सन ऑफ लेट जेडी शर्मा 59 एक्स आर्मी पर्सनल नियर आर्या हॉस्पिटल ब्रिज नंबर 5 सुजानपुर पठानकोट मुख्य भूमि से पोर्ट ब्लेयर आने के उपरांत उपस्थित थाना हुए, जिस पर एसएचओ पीएस पाड़वा द्वारा एग्जीक्यूटिव मजिस्ट्रेट राजेंद्र पाल बीडीओ के समक्ष बयान अंकित किया गया, जो इस प्रकार है। 5 फरवरी 2018 को मैंने अपनी बेटी भावना की शादी पठानकोट निवासी विनय शर्मा के बेटे नीरज शर्मा से करवाई। शादी के दौरान भावना के ससुराल के मांग पर मैंने उन्हें 5 लाख रुपया कैश दिया तथा 20 तोला सोना और 5 लाख रुपया खर्चा भी शादी में, जिसमें नीरज के परिवार वाले के कपड़े आदि थे। 5
So there are two things here. The first thing is date of marriage, my lord has noted 5th February 2018. This is very, very vital. Why? Marriage has taken place at Pathankot 5th February. Now he is describing what my learned friend said, 5 lakh. This is gift he has given. Now this gift has been given together with some clothes and gold. Now kindly see 28/2/2018.
को शादी के कुछ दिन बाद जब हम भावना की ससुराल गए तो भावना के सास और उसके पति नीरज ने कहा कि मेरी अपनी बेटी के वापस ले जाओ, हम इसे रखना उसे। उसकी पहली बार नीरज के भावना में हाथ उठाया और उसके घर वालों ने 5 लाख की मांग करी।
Stop. So 28th of February, there is a incident where Neeraj is hitting the lady. The mother was there. And they are saying there is a demand of 5 lakhs.
तब भावना ने बताया कि नीरज के पूरे दिन घर से गायब रहता है और जब घर आता है तो अपने जेठानी रजनी शर्मा के रूम पे जाके टाइम स्पेंड करता था, और भावना ने नीरज और उसके जेठानी रजना को कॉम्प्रोमाइजिंग पोजीशन में रंगे हाथों पकड़ा।
Now your lordship has understood. Neeraj was supposed to be having an affair with someone else. So the wife was unhappy. Now kindly see the time factor.
पकड़ा तो इस बात को लेके हम भावना को समझाया। अप्रैल के महीने में जब होगा, भावना और नीरज हनीमून के लिए केरला गए, तब हमें भावना ने बताया कि हनीमून के दौरान नीरज अक्सर किसी पलक नाम की लड़की से बात करता था।
So this is the second girl. So Neeraj is alleged to have an affair with Rajni, an affair with Palak. He is talking to Palak on the phone during the honeymoon.
और उसके बेडरूम में सारी बातें उसके साथ शेयर करता था। जब इस बात को भावना भी अपनी सास को बताया तो उसी सास ने कहा कि सारे मर्द ऐसे ही होते हैं।
This is the cruelty. She complained to the mother-in-law that your son is talking to other women, he is having an affair, and the mother-in-law said, what can I do? All men are bad. This is the cruelty. Now kindly note one thing. When did he go for honeymoon and where? Marriage happened in February in Pathankot. April, They went to Kerala. And then kindly see where they went.
हनीमून से सीधा वापस अंडमान
सीधा वापस अंडमान आया. So this lady got married in February, did not stay in the matrimonial home, went for honeymoon to Kerala. From Kerala, straight they came to Andamans, because Andamans, the husband was posted in the Navy. So there was no contact between in-laws and the girl. The only contact, that allegation of 20th February. No, there's more. More, I will show why this case is absolutely nonsense. Now, this is the basic thing. Now, she comes to Andamans. From 2018, she never made any complaint. She never did anything. Now, kindly see what happens. Kindly see page 62. So, father-in-law, brother-in-law, sister-in-law, there is not one whisper. So far as mother-in-law was present when husband has slapped her, and other allegation is mother-in-law said all men are like that, they are having affair. This is the cruelty. Page 62. 62 is a crime scene report.
But in spite of that, one child was born.
Yes, and child, kindly see page 62. How brutal a mother can be. Page 62, brief history of the case. On 8/7/21, one lady, namely Bhavna, committed suicide in the kitchen of her house, and her daughter, age 1.5 years, was found dead. On reaching the spot, it was found the spot was protected by police. The latch of the main door was broken open from inside. So it was locked and broken. Now, kindly sees the inquest and the PM with regard to the daughter. Page 91 and 99. 91 is the inquest of the baby.
Apart from that, there is no other.
Nothing. So what the court was asked, what the court looked at, went through entire record, all statements, all materials. And the court said, these people never came here. There is no call detail. There is no telephone. There is no allegation of threats of any abuse. But why these 4 people will be harassed with unnecessary trial?
So, you want to say anything in case? Are you? So are you a party?
Yes.
The 54 of.
Party?
No, he is not a party in 52. Can हो तो complaint.
कंप्लेनेंट को क्यों करेंगे?
And. United Council appealing for the steps acting. I have concluded their submission. So, however, as another connected matters. He's here. 4 of
24.
24 is pending. And United Council appearing. Fact of company. Once an accumulation. Moving address in place for the hearing on and which time you want to use. Well, overstanding this, only no, I'm not saying.
My lord, matter is already argued. What more material will be there?
You are not interested.
52.
52 we have argued.
52 we argued.
54.
54 is filed by me. So 50 over 50.
My lord, only one more thing. Page 158, that order which my learned friend showed. Kindly see the entire paragraph. Because 158, the impugned order in the petition. I just want to read that finding after going through the entire record, because the court did not just simply look at it like that. My lord will see the impugned order, page 152 onwards. First, kindly see page 156. Internal page 4. No, my lord, not in this one. This is the stay application. Other petition.
वही yes yes
Acha, okay. Yes, yes. So internal page 4. On perusal of entire record in the middle. Internal page 4. Next page. On perusal of entire record, I find that the marriage took place in Atho. They came and started and rented accommodation in Andaman, May Atho. If that be so, residing of other persons except Neeraj with the deceased at Port Blair does not arise. Thereafter, the description of that incident of that day, soon before the death, that is entirely there. What is most important is the last page, page 6, the findings. I do not find sufficient materials because there were omnibus, bald allegation, my lord knows 498A, buried log, that sort of thing. I do not find sufficient materials against rest of the accused persons, namely Vinay, father-in-law, Aman, brother, Praveen, sister-in-law, Shashikala, mother-in-law, to frame charge under section 498A, 304B, 34, as because prosecution prima facie failed to show their presence either at the time of incident or before that at Port Blair, as because admittedly Bhavna Sharma and Neeraj were residing at Port Blair since May 2018. Prosecution also failed to produce any call detail record showing that Bhavna Sharma was ever harassed over phone by other accused persons of this case, or any other accused person instigated accused Neeraj Sharma to commit torture over telephone. There is nothing.
Okay.
My lord, let it be parted. No, my lord, I am saying let there be a specific direction, matter be marked parted. My lord. कल अगर नहीं आएगा तो सब